In this video, we will conclude this week's module by looking at the limits Article 2 places on the freedom of contract in the specific context of agreed remedies. That is, terms in the parties' agreement addressing the kinds of remedies that may or may not be available in the event of a breach. And in particular, we will look at two types of agreed remedy terms: liquidated damages provisions and provisions that limit the amount or type of damages available in the event of a breach. In one sense, agreed remedies are like warranty disclaimers, often used to limit the liability exposure of a party, almost always the seller, in the event the contract is breached. In another sense, however, agreed remedies are very different than warranty disclaimers. To understand how, think about what a prima facie case requires to recover for a breach of contract. A plaintiff making a prima facie case must show the existence of a contract, that is, that a contract was formed, that the defendant breached its obligations under that contract, which will necessarily require the plaintiff to show also what the terms of the contract were, and even then, the plaintiff cannot recover unless she shows she suffered damages, suffered an economic loss as a result of the defendant's breach. A warranty disclaimer changes the contractual duty of the seller as to the goods required under the contract. It changes the nature or quality of the goods the seller must furnish to the buyer. Stated differently, a warranty disclaimer changes what it means for the goods to be conforming, what types of goods might constitute a breach of the contract. By contrast, an agreed remedy does not affect the seller's obligation with respect to goods to be furnished under the contract. Instead, it changes the consequences for the seller furnishing non-conforming goods. In the event of a breach, the buyer's remedies are fixed or limited by the parties' agreement. Thus, with an agreed remedies term, the parties opt out of the default rules regarding remedies provided for in the UCC. Stated differently, the default rules in the UCC regarding remedies are merely another form of gap filler, remedies that are available in the absence of the parties' agreement to the contrary. Here it's helpful to first preview the default rules regarding remedies under Article 2, default rules that are largely consistent with the common law of contracts. Recall from your study of the common law of contracts, the underlying principle for all contract remedies is to protect the non-breaching party's expectation interest, to compensate the non-breaching party for the benefit of the bargain by putting the non-breaching party in the position she would have been, the position she expected to be, had there been no breach. Typically, this is accomplished by awarding the non-breaching party monetary damages to compensate for the breach. So how does the expectation principle play out in the context of Article 2 contracts for the sale of goods? We will briefly overview that now, but we will come back to it and cover it in detail later in this course. So for now, this is just a preview. There are two possible scenarios to consider here. First, what happens when the seller breaches, and second, what happens when the buyer breaches. When the seller breaches, the buyer's remedies will depend on how the seller breaches. The seller might breach in one of two ways. First, the seller might simply fail to tender the goods that she promised. She simply fails to show up with the goods, in which case the buyer is entitled to cover, that is, buy from another seller substitute goods elsewhere, substitute goods that are comparable to what the breaching seller promised to provide. In this scenario, the buyer's direct damages, that is, the damages necessary to put the buyer in the same position she would have been had there been no breach, would be the difference between the cover price the buyer had to pay for substitute goods and the contract price under the breached contract. That is, the price that the buyer expected to pay for those goods had there been no breach. Alternatively, the seller might tender the goods, but either the seller's manner of tender or the goods themselves were non-conforming, that is, failed to comply with the requirements of the party's contract. As we noted in last week's module, in this scenario, the buyer may reject the seller's non-conforming tender, in which case the buyer's remedy is the same cover remedy that we just described. But the buyer may instead choose to accept the seller's tender despite the fact that the tender was non-conforming, in which case the buyer must actually pay the seller the contract price for the goods, but the buyer did not get the full benefit of the bargain. After all, the seller's tender was non-conforming. So the buyer is still entitled to a remedy for the seller's breach. So in this scenario, the buyer's direct damages would be the difference between the value of a conforming tender, that is what the seller was obligated to provide and what the buyer expected to receive, and what the seller actually provided, non-conforming goods. We have now considered what happens when the seller breaches. What about when the buyer breaches? In that scenario, what are the seller's remedies? Typically, a buyer will breach a contract for the sale of goods by wrongfully rejecting a conforming tender and refusing to pay the seller. In that case, the seller has a right to attempt to resell the rejected goods to another buyer. And if so, the seller's direct damages, that is, the damages necessary to put the seller in the same position she would have been had there been no breach, would be the difference between the resale price the seller can get by reselling the goods to another buyer and the contract price under the breached contract. That is the price the seller expected to receive for those same goods had there been no breach. In all of these scenarios, whether we're talking about a breach by the buyer or the seller, the measure of damages that we just described measures only the non-breaching party's direct damages arising from the breach. In addition to direct damages, however, the non-breaching party may be entitled to recover consequential and incidental losses, losses that the non-breaching party suffers not directly from the breached contract, but losses that she suffers indirectly as a consequence of the breach. That is because in all cases, the default remedy reflects the same underlying principle to put the non-breaching party in the position she would have been had there been no breach. As we noted at the outset of this video, there are two ways that parties may by agreement attempt to alter the default rules regarding remedies. The first is liquidated damages. The parties can agree in advance in the express terms of their agreement on the damages that will be due in the event of a breach. Stated differently, the parties can specify or liquidate the measure of damages in the terms of their contract. Here is an example of a liquidated damages clause. Press pause now and take a moment to read it. The rationale for a liquidated damages clause, the reason contract parties might agree to something like this, is that if you're the non-breaching party that is the victim of a breach, it avoids the problems of having to prove your actual damages. As you might recall from your study of the common law of contracts, to recover damages, the default rule is that the non-breaching party must be able to prove her damages with reasonable certainty. Speculative, intangible, or psychological losses may not be recoverable because those kinds of losses cannot be shown with reasonable certainty. A liquidated damages clause avoids this problem. It allows the parties to reduce an abstract harm that would be caused by a breach ex ante into a concrete value, a liquidated amount. Likewise, if you're the non-breaching party, a liquidated damages clause would simplify and reduce the cost of litigation. The only issues would be whether there was a contract and whether the contract was breached. The actual amount of damages resulting from any breach would not need to be litigated. A final rationale for liquidated damages is that especially if the liquidated amount is large, it has the effect of deterring a breach. By specifying ex ante the damages recoverable upon a breach, a liquidated damages provision can create an incentive for performance, a concrete disincentive for breaching. However, both under the common law of contracts and under Article 2, liquidated damages provisions are subject to special judicial scrutiny. Stated differently, liquidated damages provisions are not always enforceable. This is another situation in which the law does not simply defer to whatever the parties agreed to. The rationale for limiting the freedom of contract with respect to liquidated damages is that liquidated damages may be used to impose a penalty or punitive costs for a breach of a contract, and that undermines a central tenet of contract law, the compensation principle. As you may have learned from your study of the common law of contracts, a central tenet of contract law remedies is to compensate the non-breaching party for the economic harm caused by a breach. The goal is not to punish the breaching party or deter future breaches. For that reason, punitive damages are typically not available in a claim based on breach of contract. Punitive damages go beyond compensating the non-breaching party. They punish the breaching party, and the goal of contract law is not to overcompensate the non-breaching party from an economic perspective that would deter an economically efficient breach. So, consistent with the common law of contracts, Article 2 places limits on the enforceability of liquidated damages. Specifically, subsection 1 of section 718 imposes a limit of reasonableness, a test that is essentially consistent with the common law test. The amount liquidated as damages in the parties' agreement must be reasonable in light of three factors. The first factor is the anticipated or actual harm caused by the breach, and this is by far the most important factor. If the amount liquidated is unreasonably large as compared to the actual harm, or the harm that was anticipated by the parties ex ante when they agreed to the liquidated amount, the liquidated amount may be void as a penalty. Second, the amount liquidated must be reasonable in light of difficulties of proving loss. And third, the amount liquidated must be reasonable in light of the inconvenience or non-feasibility of otherwise obtaining an adequate remedy. These last two factors stem from the common law's requirement of reasonable certainty. As we noted earlier, under the common law of contracts, the non-breaching party must be able to prove their losses arising from a breach with reasonable certainty. And if the nature of the loss is speculative, non-economic, or otherwise difficult to prove, the requirement of reasonable certainty may serve as a bar to recovery. So the more difficult it might be for the non-breaching party to prove such losses, the more reasonable it would be to attempt to liquidate those losses in the parties' agreement ex ante. If the amount liquidated in the parties' contract is unreasonably large in light of these considerations, the court may rule that it is unenforceable, that it is void as a penalty, in which case the non-breaching party would not be entitled to recover the liquidated amount, but would still be permitted to recover under the default damages rules of Article 2. One final point to make about liquidated damages: note the last sentence of subsection 1 does not say what happens if the liquidated amount is unreasonably small as opposed to unreasonably large, in light of these three factors. But the implication of the last sentence is that it is not void as a penalty. Even so, such a provision, liquidating an unreasonably small amount, might be still unenforceable under the doctrine of unconscionability. So that concludes our look at the enforceability of liquidated damages under Article 2, and it brings us to limitations on remedies. Just as parties may agree to liquidate an amount for damages in the event of a breach, the parties may agree to limit the buyer's remedies, limiting the forms of damages or the forms of remedies available to the buyer. For example, the parties' agreement may cap the total damages available to the buyer in the event of a breach, limit the buyer's remedy to a repair or replacement of the goods, or limit the buyer's remedy to a refund of the purchase price for the good, or limit the seller's liability for any incidental or consequential damages that the buyer may suffer. Here is an example of what such a limitation might look like. Press pause now to take a moment to read it. Section 719 of Article 2 governs terms that modify or limit remedy, and it is a complex provision, so it is helpful to analyze it in individual pieces. Subsection 1a confirms the limitations on remedies are enforceable. But note the introductory clause of subsection 1a, which says that it is subject to, among other things, subsection 2. Subsection 2, in turn, says that limitation on remedies is enforceable unless the agreed upon remedy fails in its essential purposes. So we can only say that an agreed remedy is generally enforceable, but not always. This essential purpose test envisions a scenario where the remedy allowed for in the parties' agreement does not give the buyer what she reasonably expected. For example, the agreement limits the buyer's remedy to a repair of any defective goods, and every time the seller repairs it, the goods break down again, or the seller takes a very long time to repair the goods, or the goods are of a type that are not repairable under the circumstances. In any of these scenarios, where the agreed upon remedy fails its essential purpose of giving the buyer what she reasonably expected, then, under subsection 2 of 719, the court may disregard the agreed upon remedy and instead award the default remedy that would be available under the UCC. So there's effectively a limit or outer bounds on the enforceability of an agreement that limits a party's remedies upon a breach. And the rationale for this limitation seems to be simply that a seller should not be allowed to escape all responsibility to the buyer for the seller's breach. Subsection 1b adds an additional nuance, articulating a rebuttable presumption. Specifically, simply because the parties agree to a term specifying a particular remedy in the event of a breach, that does not mean that the agreed upon remedy is exclusive of other remedies, unless the agreement specifies that the agreed remedy is exclusive. Stated in the language of the statute, resort to a remedy as provided in the parties' agreement is optional unless the remedy is expressly agreed to be exclusive. So subsection 1b creates a rebuttable presumption, the rebuttable presumption being that in the absence of express language to the contrary, the buyer's remedies are cumulative. Any agreed upon remedy is only one option the buyer may pursue. The buyer may instead also choose to seek the default remedies that are available to the buyer under the UCC instead of or in addition to any agreed upon remedy. From a drafting perspective, this rule makes it very important for terms specifying an agreed upon remedy to make it clear that the agreed remedy is the exclusive and sole remedy. Press pause now to take a moment to read this example clause to see how a contract might do this. In the absence of this kind of sole and exclusive language, under subsection 1b, the non-breaching party may be able to go around this provision and seek its default remedies under the UCC. Finally, subsection 3 of 719 addresses the enforceability of terms that limit consequential damages. Such terms are not uncommon. A seller may reasonably want to limit liability for any consequential damages. You are probably familiar with consequential damages from your study of the common law of contracts, and there's a great example of one provided in your reading. As that example suggests, a seller may be perfectly willing to pay a buyer for the difference between the seller's non-conforming good and a conforming good. But a seller may reasonably not want to pay a buyer for the buyer's business losses for waiting for a conforming good to arrive, or if the non-conforming good burns down the buyer's house or business facility. Subsection 3 generally confirms that a term limiting or eliminating consequential damages is enforceable, but only up to a point. According to the first sentence of subsection 3, such a term is enforceable unless it is unconscionable. Arguably, this first sentence is unnecessary. It's superfluous. After all contract terms are subject to the test of unconscionability. But the second sentence of subsection 3 does add a new detail for us, which is that a limitation on consequential damages for personal injuries caused to a consumer by a non-conforming good is per se unconscionable. Note, this limitation does not apply to all terms that may limit the recoverability of consequential damages. For one, it does not apply to limits on purely commercial or economic consequential losses. It applies only to preclude the enforceability of limits on consequential damages arising from personal or bodily injury. Moreover, this sentence does not apply at all if the buyer is a business or merchant. It applies only to preclude the enforceability of limits on consequential losses where the buyer is a consumer. So, consistent with the broader theme of this week's module, Article 2 does not provide for a complete or untrammeled freedom of contract for the sale of goods. Although the space for the parties to customize their contractual obligations is quite broad, we have seen now in several areas, including in overriding the gap filler provisions of Article 2, in disclaiming express or implied warranty, and in agreeing to limit the amount or types of damages available in the event of a breach, the ability of the parties to agree to whatever they want is limited by Article 2, at least on the fringes. In next week's module, we will complete our look at how Article 2 governs the terms of a contract for the sale of goods by examining the sometimes inscrutable parole evidence rule.